First of all, hello everyone. This interview is intended to serve the purpose of experiential learning in the subject of IPRE in our course. With us today is Ms. Aishwarya. Could you please give an introduction of yourself?
Yes, hello everyone. So this is Iswariya. I'm basically I have done my BCom series in Ethics College for Women, and I have passed out in the year 2020 and have also completed my ACS or the professional course of company secretary. I have passed out in the month of December 2021, and I am right now doing my internship in a firm called as CR and Associates. So that's about myself.
All right, thank you. Then we can get started with the interview.
Done.
So the first question is that we've been taught intellectual property rights in our class while emphasizing its significance and importance. So what we want to understand is through your perspective, why intellectual property right is so important for an individual, organization or a group.
Yes, from our young age, we all know there is a subject called as IPR. We all after hearing that word, we all think like it is a different subject or something. But it is something basically we all know, but we all fail to understand what it is basically. Um, all of us don't like when someone else steal our things. So this is exactly the same thing. When we ourselves think about something or we ourselves has an idea to do something in that way, and when someone else copy and do that, then it will for sure affect us. So that is where intellectual property rights come. So when we have an idea, we thought of doing something, and when we have to execute something, then it is also necessary to protect what we have thought or what we had planned. So this IPR protects us the ideas or invention or our way of thinking or whatever we have to execute those things. So that is what IPR basically is. And it also protects when it comes to an individual perspective, it will protect their own labor and the way that person has thought, has spent time for this, for executing that work. And when it comes to company's perspective, it will increase the value of the company. So the assets of the company basically will include both tangible and intangible, and this IPR will come under intangible assets. So that will increase the value of this company. And even when the company is going for any other like a big thing and going for the general public for issue of shares, or when it goes for merger, or when that company is being taken over by the other company, during those times, this intellectual property plays a very major role. And that will create a more value for that company, and that will be considered as a major part at the time of takeover. So that's how intellectual property basically.
Okay. So next question is about what are the various laws in India that protects the intellectual property rights of the individuals and groups that we just spoke about.
Yes. So in India, we do have various laws which protect intellectual property rights. And basically, so many of us know there are first three common laws, which is one which is patent, and the next one is trademark, and the third one is copyright. Patent, which will protect the inventions, and mostly will relate it to scientific inventions and those things. And when it comes to trademark, it will be the mark or the word mark that will protect from that perspective. And when it comes to copyright, it will protect like uh, the literary kind of things, and cinema, something like sound recording. When it comes to media industry, copyright plays a major role. So these are the basic three intellectual property laws which everyone are aware of. And there are few other laws which are there in India which protect IPRs. Those are there is a law called as law which protects geographical indication of goods. So that law is basically for when a product is from a specific state or country or specific district, and when it goes and gets sold out of India, when it is exported. So during that time, that product, it will this IPR will protect that product's like what that product's origin state. So that is how that law protects protects. And there is a law called as industrial design. So that law basically protects like when, for example, if we take like there are so many things when it comes when we watch an advertising. There are things like when we take Induleka hair oil bottle, it is designed differently. So it is designed for us to easy to apply. So that is a different design. So that is how, and for the industry, not to get like it will protect that company from someone else to copy the way that bottle is designed. So that's how industrial design that will protect the thoughts and ideas of that company. And there is one more law called as protection of plant varieties and farmers' rights. So that law will protect the rights of the farmers. So basically, in agricultural, there are so many seeds which are used for planting the food which we get. So in that, they may do research. They will do a lot of research for like getting so many different kind of products. So to protect that thing, we have something called as plant varieties and farmers' rights law, and there are so many other laws too in India. Yes.
Okay, so the next question comes with the issue of patent. So in 21st century, as you know, digitalization is growing fast pace and we are producing tons of data every single day. So how does the patent office ensure that they gather all the information from this database in order to validate and verify the issue of patent?
Okay, from the patent office perspective, how
Yeah,
do
from
they?
handle.
Okay, how do the patent office handle?
Yes.
Yes. So I basically first tell like how we have to do research before we applying a patent, and then I'll tell how the patent office works. So before we apply a patent, there is a specific process. It's not just like we will think about what to do and to execute a plan and to go and register the patent. It's not like that simple process. First, before registering a patent, we have to do so many R&D work. The basic thing is we have to first know like whether someone else has already done this kind of invention or this kind of work have they already done, and whether that work is already registered, and for how if registered, for how many years are they working in that field. So we have to do all kind of those research. Only after that we can apply our patent. So that will be a very good move before we go and apply for the patent directly. So we have to basically check what we are going to claim in that patent application. So if our invention is something, we have to tell basically what this invention, in this invention, what we are going to claim and claim for patent. So we have to first check like whether that claim is already claimed by someone else, and as we have to check whether it is similar to us or the product which is given, like the outcome of that patent is similar to what our patent is also gives. So we have to do all those kind of research. So to do that research, the patent database has given like so many facilities. When we go and check the patent portal, like the website of the patent offices, so they will uh, provide various like there are so many tabs under which we can go and check under like invention tab, or whether the claims which have been claimed by the other patents. So when from our side, when the patent office has given so many tabs for us to go and check whether this is there and this is has whether that has been claimed by anyone else, the same applies to the patent office also. So even from their end, they will do the same before giving approval for the patent or before raising any queries for the patent application which is made by the applicant. They will check all the patents which has already been submitted. So they will check whether that is a true, like whether that applicant has taken necessary steps and whether he is a true patent applicant. So that is how they will basically check. Based on the application which is already submitted and which is saved in the database, they will segregate it and they will check it. So that's how they will do it.
Thank you so much. Now my friends will carry on with the interview. Thank you.
Yeah.
Hello. So I wanted to know that now that we know how patent we get patent and everything, now let's assume that there's a person who has a patent and he gets to know that he or she gets to know that there's a infringement of uh, their patent. So now how do they go about like protecting it, and how can he file against the person, and what is the duration fee, and will there be any compensation, or if there is a punishment, what kind of punishment is will the person feel?
Yes. So the main aim of the IPR itself is to protect the idea of a person or an organization. So for sure, when there is a law to protect something, we will always have something to protect when it is infringed by someone else. So this law to also have the various provisions for infringement. So when a person who has invented something and has come to know like the exactly his claim has been all is claimed by someone else, or someone else is using it. If it is a product, if someone is buying and selling the exact product, if it is a process when someone is using the process which he has invented for selling, for like producing his goods or something else, then he can for sure file an application before the patent authority, who is like the controller. So he can file an application stating that this is what his patent is, and he has already submitted the necessary form with the authority for receiving the patent, and he was he has already granted a registration for the same, and he came to know like this person has infringed his patent. So that's how he has to list all the matters, like what exactly that person has infringed, and he can tell what's the compensation, and he can let the he can tell like what are the things influenced by that person, and he can submit the same before the controller. I'm not sure about the form and the duration, but as soon as he comes to know, he can submit the same to the controller. And even if there is a delay, and he can give a reason, like a right reason for his delay, the same will be accepted by the controller, is what I guess. And when it is influenced by someone, the remedies are always available. So when the controller, after receiving the application from the person who is stating that his patent is infringed, the controller will examine the application which is submitted by this person and also the other person who has infringed, and he will compare, examine, and do all those things, and then he will come to a conclusion that whether it is a infringement or not. And when it is infringed, the patentee will have like proper compensation in that regard. He will compensation in the sense he will have, if he has suffered damages because of that, then the damages will be paid off. And he may also request the controller to give an injunction order to that person of not to do, not continue, stop continuing doing these kind of acts. So that's how he will receive the compensation for infringement under the Patent Act. And the same applies to all the IPRs. When it is infringed, he can let know the same to the respective authority for the proper compensation.
Okay, so one more question is, from your point of view as a CS, what do you think are some of the challenges in intellectual property rights and the protection of IPR?
Challenges. First challenge. Basically, so many people don't know about patents and the IPR. And when it is infringed, few people can tell like it is not infringed. They may have their own ideas of doing that. So when we have a client or something who has like properly invented something and has received a registration and has granted registration for the same, and when he comes and tells like his patent or his some other IPR is infringed by someone else, then we have to ensure that it is for sure, like we have to submit necessary proofs before the authority for proving our statement. Like that is a really hard thing. We have to prove that the other party has infringed like he has the intention to infringe and to make profits. We have to prove it, and that is a bit difficult, is what I feel.
Okay. One last question. Now that Nitya told that in this era of digitalization, do you think there's any effect with the like process of IPR with automation coming in?
Like the development in IPR.
Yeah, like the process of applying and has it made your job easier or harder or to differentiate it also?
Yes, like I guess we can submit all the form. We now we have submission of forms for patent and all, both in physical mode and in online mode. So we have a schedule itself in the patent rules stating that all the forms for submission of patents or for filing applications and all, it can either be submitted online or physically. So when we submit it online, it will even reduce the cost. There is a fee schedule which lists like for physical filing, it costs a bit more than the online filing. So that's how the like the change made like the work easier, is what I'll tell. The time which is required to submit and going and coming to patent offices, that is reduced.
What about at the other end, like uh, how the people at the office, has it been easier for them or harder for them?
It will be easier because going like reading page by page, it will be easier for them to read it in the system, and to even to save the copies or documents which we have submitted. It will be easier for them to save it in a one place or in one desktop instead of having a place for keeping those documents on. Even more like instead of it's even more harder for preserving the documents in a exactly the same way in which the person has submitted.
Yeah, thank you. That's it from my side. The others will continue.
Hello, ma'am. Am I audible enough?
Yes,
So basically, my question particularly is about when you're talking about laws and all, how does a particular country ensure that the protection of patent rights of its citizens and in the same country as well as in other countries? For example, if there's a patent that is done in India, how is the country ensuring that the patent is basically protected in India as well as in the other countries?
yes, we have something called like filing of a patent. When a person wants to submit his IPR and he wants to protect the IPR both in India and also in other country, he can make an application both in India and also in the other country in which he has to make an application. We have, and it is other way also. The person who has invented in other country, and if we want to protect his patent in India, then he can submit his application in India also. And we have separate provisions for that. Like when the person has already submitted that patent in the other country and he is coming to India, then the date of prior art and the date of taking, like when that patent has been granted, those days will be calculated from the date on which the patent was registered in the other country. And exactly it is like when the person has given in India first and then in the other country next, and the date in which the person has submitted in India will be considered as first. So his invention will have a prior art, even though he submit a bit delay in the other country, he can claim the date on which he has submitted that patent in India. So that's how the country of origin in which that person has submitted his patent first will have the importance.
The other question I had in mind, ma'am, was what are some of the treaties that are basically in between India and other countries related to IPR, and especially in terms of patent, and how is it actually impacting the actual organization part of it?
For the first question, we have so many treaties which has been executed between countries, and we have, when it comes specifically to patent, we have something called as patent cooperation treaty, and we have something called as TRIPS. which is called as trade-related aspects of intellectual property rights. So we have something called that agreement is there between countries, and um, we have something called as Berne Convention, I guess. So we have so many treaties which is executed between countries to protect the patents, not only in their country and also between other countries.
And the last question from my side would be, like, when we talk about IPR, one of the major things to consider and understand are the theories that we are talking about IPR. For example, the moral desert theory or the utilitarian theory and others. Out of all of this, as per what is your experience, what does your experience tell you that what is the dominance of these theories inside the current working of organizations?
My experience, mm, so 1 minute. Can we switch this question? Like, can we go to the next question? I'm not sure about these theories.
Sure, we can now. Hopefully now Shreyansh will continue with the same.
Yes.
Yeah. So my question regarding this discussion is, as we discussed during this interview, you and we all agreed to the point that most of the people in India are not aware of the patent rights and the patent rules that are existing in the law. So, how do you think like we can make people more aware about these rights? Because nowadays people are interested in starting a startup. So these patent rights play a crucial role in doing that. So if I have to ask you, like, what do you think we should do in this country to like increase the awareness among the people regarding the patent and its rights?
For creating awareness, uh, we basically already have all these theories, all these laws in our book, but the same is not known to so many people. And even if we know, it is only for exam purpose. So basically, people don't like really wish to know more about these things. They just read and they will skip the chapter. So that's how it is. So to increase the awareness, it is better if we go for like in schools and all, if we go for competition kind of things. So that's how I think we can like increase awareness and to do projects and to do to write articles and publish the same. So that's how I think like we can create awareness and we can tell the importance also.
All right. Moving to the next question. This is something that happens with all of us. Like maybe I also sometimes do it without the proper knowledge. Like when there are many things that have been created by various companies or industries, especially if I have to talk in terms of music industry, we take their music, we copyright, like we break the rules by not following the copyright rules. And similarly, there are many companies that may manufacture some products that people are not aware of. If they copy it or make a duplicate copy of it, it can lead to like laws, especially in regards to the patent. So, if I have to consider a point like many people might in big companies thought of this process, like what if the product gets copied by some small firm? So is there any way the big companies tackle this thing, or like is there any thought process that goes on while developing the product to ensure that these things are not infringed or copied?
Like we wish when someone is doing something, the person already wish that the same must not be copied by someone else, and that is the major objective of this law, these laws itself. So the intention of all these laws is to protect the ideas of someone. So it is not required for the person who is preparing or inventing or writing about something to have in mind for protecting his invention or patent. So the laws already protect all these things. So what basically a person has to do is he has to take proper action when he comes to know like someone has infringed it. So he has to take uh, proper action with a proper duration, like as soon as he can. So that is the first step which he has to do. And the next thing, So proper actions has to be taken. And one more thing which can happen is like from the authority perspective, when someone has infringed, it will be proper. It will, if they complete the infringement process, like the hearings and all those stuff within a within a short span of time, and give the order. So when the person comes to know like his patent has been infringed by someone else, then he will be uh, if the process of adjudicating, if the adjudicating process is it is a time bound manner, then the person whose patent is infringed will come forward to raise a complaint. So that is how it will be. So that is what I thought, like, to tackle the issue. Like, yes, so that's
Okay. So coming to the last question of this interview session, like this is an ever developing process, the patent laws. Like every time when technology develops, there might be some changes that are required in the patent laws. So if I have to ask you in terms of your experience, like what are the changes that you see in the future in the patent laws, or which are required to make this whole process more efficient and like reliable?
the amendments which has to be done in the Patent Act and IPR laws is like what I have answered for the previous question, to make a speedy disposal of the cases which are being filed with the authorities. If the same is being done, then the awareness about IPR will also increase, and persons who has created something will come forward to register themselves and get a registration for their inventions also. So if we complete the process within a proper time limit, so that will automatically reflect in the number of applications, which is application that will be filed before the authorities. So that's my view.
Okay, thank you, ma'am. That's it from my side. Like any
Yeah.
other has a question?
Krishna, do you want to ask any other question?
Sure. So, apart from the standard rules of IPR, including the patents and everything, is there anything in both terms, in the beneficiary side or in the benefit side or in the side, is there anything that has come into picture after the pandemic came? Is there any changes in the laws, or is there anything that has to be inculcated after the pandemic came into picture? Is there any sort of difference that has been happening?
Like in the patent laws.
Yeah, in the patent laws or in the process of all of this patent filing after the pandemic came into picture.
Yes, during the pandemic, a major thing, like the major law which has been seen as the like IPR law, because we had vaccines which has been introduced, or which were introduced and invented, like, for us to get rid of COVID. So during that time, what we basically had is the person who has invented that respective vaccine will have all the rights. So that person will so we have law, and we have laws which is there in Patent Act, which tells like when there is an national emergency cases, during that period, it is necessary for the person who has invented to give a license to everyone for using of that patent. So when the person who has invented during the COVID period, a person who has invented a vaccine, uh, even if he is not like even if he doesn't wish to give license to the other person by charging the royalty for them to use or produce or manufacture and distribute the vaccines which he has invented, the government has the authority, a right to allow the other person who is in the same field of manufacturing and distributing the vaccine. The government has the right to ask that person to produce the same vaccine. So that is something called as compulsory licensing. So during the pandemic times, that was like uh, a major discussed thing. So many companies which has introduced vaccines has like refused to give a license to the other person. So during that time, the government has played the major role. So that is what which has done, which has been done during the COVID period.
Okay, I don't think anyone else have any other questions. Does anyone else have any other questions? Or no?
Nothing from my side.
I think okay. So I think it was a very fruitful interview. And if you have any last piece of note that you want to give with regards to IPR, you can say, and then we can conclude the interview.
So like one question which you guys have asked is like how to create awareness about IPR. So that is what you guys have asked. Like IPR is a subject which everyone, as I said in the beginning, IPR is something which we all know, but we all don't really understand. So it will be better if we take initiatives for creating awareness and making people aware that there is something law which protects our way of thoughts and ideas, and the same will be like, and the same can be utilized by so many people, so that the country will also develop in large.
Sure. Thank you so much for doing this interview with us. It'll be really helpful for us to understand and work on such ideas further and how to increase awareness in the country. Thank you so much, Ms. Aishwarya.
Yes, thank you.
Thank you.
Thank you, ma'am.
Thank you.